Dear audience, thank you for staying with us in 2022 World Intellectual Property Forum in the panel Artificial Intelligence and Intellectual Property. After our honorable speakers, Kurt and Chirag, they have introduced American and Indian scenario. Now we will come to the European perspective. We will have the Yannis Skoulikaris, the founder, managing director of PatentMind, who will introduce the European progress and development for AI patents so far. Before we turn the floor to Yannis, allow me to give a brief introduction of Yannis for his legendary history. He has been working for EPO for over 30 years in the Netherlands as a patent examiner, and from 2002 and 2019, he's a director and for patent granting process in information and communication technology. And his background in physics and computer science, graduate from prestigious University of Hamburg. And in the past 5 years at EPO, he has co-drafting the examiner's guideline for examination of computer implemented invention and including artificial intelligence invention. In the same period, he had managed bilateral comparative study in patenting practice of computer implementing invention with the JPO, Japan Patent Office, and CIPO, China National Intellectual Property Administrative and the Chinese Patent Office. After Yannis left EPO in 2020, he founded a group of company branded PatentMind as a synergetic network distinguished IP professionals. And under his platform, he operated as an independent intellectual property consultant and China specialized on patent of software and artificial intelligence technology. His law firm, PatentMind LLC, operating as a rescue service for difficult patent cases and risk going the most challenging way. And Yannis covered the technology side of patent prosecution, enforcement from initial concept to entry the marketplace, capitalizing the technology background, intimate knowledge of the European patent law, case law and practice, as well as his deep understanding of how patent examiners think and act. He supports his client as a technical expert in court and in filing effective amicus curiae brief. Behind his degree in physics and computer science, Yannis had followed 2 years of legal study at the University of London, and he has computer training as a technical qualified judge for the upcoming European Unified Patent Court with CB in Strasbourg, and he's a guest lecturer for European patent law, in particular patenting computer implementing invention at Law School of Massachusetts University and the Washington University of St. Louis. He has presented in the European practice in patenting computer implementing invention with emphasis on artificial intelligence technology in various fora in Europe, North and South America and Asia. He's a native speaker of Greek, and he's also fluent in English and German with working knowledge of French and Dutch. He's a senior member of IEEE and also a member of International Chamber of Commerce, LESI, AIPBI, AIPLI. So before I turn the floor to Yannis, please allow me to demonstrate how AI artificial intelligence, they could support us on litigation. Previous, I have mentioned how they done patent search, trademark search, corporate name search, whatever, and also the patent due diligence. Now is the turn for patent prosecution litigation. So I would apply the case, the Global Foundry versus a bunch of a company, in particular to TSMC in Taiwan. So on Monday, August 26, 20 2019, GlobalFoundries filed 19 patent infringement lawsuits and 2 International Trade Commission against the Taiwan Semiconductor Manufacturer Company and other defendants, including Apple, Google, NVIDIA, among others. So, in the lawsuit, which were filed with the ITC, and also the District Court of Delaware and Texas, and the Regional Court of Düsseldorf and Mannheim and Germany, and so they alleged existing of GlobalFoundries patents and have been infringed upon. So there are about 20 defendants. They were named on the lawsuit, all of the big names. The seeking the significant damages from TSMC based on unlawful use of GlobalFoundries proprietary technology and his $10 billion sales. GlobalFoundries also appeared to hold U.S. import of product as iPhone X, XS, and AirPod, and the containing processor met with the technology covered by these patents. So TSMC is the #1 pure play foundry. And this plaintiff, GlobalFoundries, is the #2. The market share seems very different. And GlobalFoundries, actually, he was a spin-off from Advanced Micron Device. And it was purely owned by Mubadala Investment Company. It's a sovereign wealth fund of the United Arab Emirates. While it has initial public offerings in October 2021, a lot of cooperation with IBM, actually also a very successful company. For TSMC, of course, is the #1 chip OEM factory in the world, working with leading companies in the world. So we just have a very quick look at the result revealed that a total 19 complaints have been filed in the U.S. District Court in Delaware and Western District of Texas. So they have 6 complaints filed in Delaware and 13 in Western District Texas. Just with one click, all the patterns in each lawsuit were identified by using AI tool. In this case, we use Patent Cloud. You may also try something else. There are plenty of the tool in the world, but this is the tool they offer educational services for our university. So we use Patent Cloud for this demonstration. Just one click. All the patents in each lawsuit were identified. By doing so, we notice straight away that 4 patents are involved in 5 out of 9 complaints against TSMC, and these are 178, 643, 357, and 877. Patent 357 does not have any rejection record in the prosecution, nor are they any validity challenge in the past grant proceeding. So, however, it's important to note that there's some potential prior art reference that may be used against this pattern in the relevant of invalidation actions. So just one click, you will quickly get the list. Not a quick view, also few clicks, you can identify the pattern GlobalFoundries choose were originally from IBM, and the quality is classified as C, values A. Also, another few click, you can have the quality insight tool in Patent Cloud, just one click, to examine the file wrapper data. You can also look into the family status tab, so you can identify any abandoned family member, which is a great strategy move when preparing an inter-party review or an invalidation action proposal. So this is a small tool in Patent Cloud. We can identify abandoned family number, for example, EP 179733182 and US 2007 0290258081. So you could quickly, you can have the global view. If we take 250 patent, for example, on the history tab, you can identify the reason why application abandoned, because they failed to respond to office action. So all the detailed file wrapper information could be easily obtained. Similarly, you can uncover the reason of abandonment for this European patent. It was rejected by the examiner. So all the history, you go through the history, there's nothing can hide, everything transparent, and only just in few clicks. So if you don't have tool, AI tool, big data predicting tools, how can you continue your work in IP profession? So here is another examples. Further, I would like to show you in the event needed to compare patents side by side. You can see the difference between the patent at issue and the family members. Simply just select the patent from the list and click compare on the toolbar. So despite the fact of title, abstract, and images seem to be same for both patents, if you can continue to browse the claim of the two patents, it's apparently that are different. Although we might not be able to make an exact judgment from this, it could give us a hint as to what caused the difference of the patent legal status. Knowing which prior art reference were used against abandoned patent is important. So if you want to focus on the prior art reference for abandoned patent, you can simply input the search bar to fill out the prior art reference, and then you can also use the same technique to compare prior art, utilize the same part, utilize the simply click and compare function. So it's no need to be afraid of those AI tools. For example, I give you a very comprehensive chart. By duplicating the above information, then we can create a comprehensive summary table of the patent issued and quickly confirm patent 357 is involving 5 out of 9 cases. And what's more, it seems to be the most valuable patent in the case. So from this, the list, this can be just one click, quickly export, and you understand the whole scenario. And this is the whole chart after we have conducted all this research for those patent issued. Of course, we don't use only one tool. I use Zeus Analytics, which is provided by IPV, our another friends who offer their tools for our education and training. So we go dig into every patent's claim compared to patents and papers, their originality. We give the score, not only for the overall patent, we dig into the independent claim. I did them one by one. You may also go into the claim chart and further dig into elements in each independent claim or dependent claim. It was just showing you how convenient and how insightful those tools can help and ease our daily work in our legal profession. So this is just some their screenshot for you to really understand what I've done on above. How can I achieve this comparison? So you can just select all patents and ask them to run. You can have all the necessary information, the spec, reference, forward citation, legal events. In particular, here I would like to highlight Global Foundry. They actually securitize the patent to Wellington Trust. It's a National Association Delaware to get the money. Before they want to file a lawsuit, 1 week before they file a lawsuit, if you remember, the file was 29th August, they returned this patent to Global Foundry. So by monitoring, sending alert from watch patents, that will help you to prepare your risk management for our IP legal daily operations, related art, foreign families, and we can also calculate the art and technology score not only for the whole patent, but also for the independent claims. And they will quickly list 80 more published most similar arts for you. You can download them. They also give you the comments for comparison, not only for the overall score, but also have the abstract score, patent family, international citation, and AI rankings based on your originality compared to all the patents and all the papers. So if you download the list, you can easily understand why TSMC become their top list for for litigation, because there are so many patents similar. They give you the potential infringer, licensee, or buyer, or future cooperative partners based on the company, which patents, and the similarities. So this is the world. The world is changing our IP ecosystem and our daily operation, and they can even do the claim chart. You may wonder, is it correct? But they have conduct the operation through AI, and we can do the further check. So human being will not be replaced, but we have our time and effort on more advanced work. They can conduct the IP reuse, and they can conduct the comparison. So if I choose this pattern, the first one, US A435, and then you can see they have mark 2. That means the similarity was not very high. But I can also choose which claim element I want to compare, so they could match and highlight the keywords. With all this tool, TSMC quickly counters to global foundry by choosing suitable patents and suitable venues. These are the pattern they choose, but we can also go into analyze those counter reactive patterns as well. So you can see all the file wrapper, all the weakness, all the histories based on different ground. They can all be analyzed. Even the claim insight comparison, family prior art, secondary prior art, semantic prior art, file wrapper search, claim analysis. It all can be done just in few clicks. So they make decision with greater context, that save time, reduce costs, optimize our legal strategy, help us prepare case faster, minimize the refusal risk, and identify clause for available search and watch, estimate the likelihood of success. So Yannis, the floor is yours. Please go.
So, hello everybody. I welcome questions also during my talk, because it may be that you don't agree to something that I say, or I say something wrong. So please intercept me at any time. That's really no problem. And then we will try to clarify things and then go on. So imagine that you are a European patent examiner. You are an examiner in the European Patent Office. And an AI-related application lands on your desk. Now, what is it about? It's a system that gets as input audio samples of people speaking English, but those persons don't have English as a native language. So their mother tongue is not English. So you have an AI system that categorizes those, that learns from those audio samples, analyzing those samples. There are some algorithms that can do really a sophisticated analysis of those samples. And the system recognizes the origin of the person, so that the native, the mother tongue of the person. And so after a training phase, then the system goes into operation, and it can be used either to replace a chatbot. So you speak to the computer in English, and the computer says, probably you're Greek. Then I'll continue talking to you in Greek. Or you can use this system, for instance, in law enforcement. So a person pretends to be Greek, but then the system recognizes that the person is of another origin. So that there are more than one ways to use such a system. So what do you do as a European Patent Office examiner? How do you go about examining this patent application? So first you will of course say, is it technical? Because you know, maybe, that in the European Patent Office there's a holy grail when examining applications in software or artificial intelligence. The invention has to solve a technical problem using technical means. So first question, is this technical in the first place? And then so on, so on. We will come back to this example a little later on, but first we will see what are the items that we will be talking about today. So first I would like to create a common understanding in the audience about what is AI, what is artificial intelligence, because there is a lot of mystification about this term. And then we will look a little into the European Patent Convention. What does it say about how do we go about artificial intelligence? And then we will see the problems that this kind of technology presents to the patent law, or at least we will try to identify those problems. And we will recur to the example and analyze it a little more, and then we will try to reach some conclusions as to what could possibly happen. Now, when I hear the term artificial intelligence, I think, maybe it is a contradictory term. So it correlates something that is artificial with something with intelligence, which is very, very natural. So is it really a correct term? Or is it a contradictory term? To my mind, it is a little misguiding, because it purports to say, we can have a computer, and this computer, properly programmed, can exhibit intelligence. This is not exactly this, but nevertheless, we will try to analyze this. One could think, maybe there is a better name for that. So I call it connectionist programming. That was an old term, connectionist, that was related to neural networks in the beginning of this technology. But anyway, so to my mind, artificial intelligence deals also only with a small part of what intelligence is. Because intelligence, if you ask yourselves what are the features, what are the characteristic features of human intelligence, then you will think of consciousness, a very, very elementary feature. You will think about initiative, you will think about imagination, free will, or common sense. And these are elements that artificial intelligence doesn't exhibit, or doesn't exhibit yet. There are some efforts to integrate those elements in artificial intelligence, but they are not, they are in their infancy. So, but artificial intelligence does excel in some other specific tasks. So you cannot beat it in chess playing, for instance, or in Go playing, which the game of Go is much more sophisticated and much more complicated than chess. And some other items, some other special tasks. But to my mind, I would like to understand artificial intelligence for the time being as something that extends the brain power. It's a brain power extender. I call it a mental prosthetic device. So imagine of a hammer, you have your hand, and with a hammer, you extend the functionality of your hand, and you can do much more than what you can do with your hand. So a hammer is a mechanic prosthetic device. And artificial intelligence is something for the brain. It helps your brain do certain things which without artificial intelligence would not be possible. For the rest of what I'm telling you, I will limit myself a little to machine learning, because artificial intelligence is a little more generic. There is the so-called symbolic artificial intelligence. We don't talk about that. We concentrate on machine learning, neural networks, and the way they function. And what I would like to postulate is that machine learning is a simulation of mental acts, basically human learning. But the system doesn't learn really, it simulates the way the human beings learn. It simulates it on more than one level, on the structural level, by programming a neural network, neurons and things like that, and on the functional level, by training the model with examples, and trying to identify regularities within the data. Something that small children do when they learn to differentiate between cats and dogs, for instance. Could I have the next one, please? So, let's see now what are the provisions of the European Patent Convention, because our main issue is the European Patent Convention still fit for purpose when it comes to dealing with inventions in this cutting-edge technology. So, the European Patent Convention asks the question of eligibility. So, when you present an invention to the European Patent Office, they will ask, is it eligible? Does it belong to patentable subject matter? Why? Because there is an article in the law that says that some things are not patentable. They are excluded from patentability. What are those things? They are mental acts, they are excluded, mathematical algorithms, computer programs, and data. And those things as such, for themselves, they are not patentable. But if we look a little at those things, so mental acts, we are dealing here with simulation of mental acts. And in the European Patent Office, there has been case law that says that simulation of technical processes could be patentable. Okay, we have that. That was a recent decision of the enlarged Board of Appeal of the European Patent Office. But we don't have any guidance yet as to whether simulation of mental processes could be patentable. This we don't have yet. Okay, so let's keep that at the back of our heads. Then, what about the next building block of artificial intelligence, namely mathematical algorithms? As such, they are not patentable, so they are excluded. What about computer programs? Excluded also as such. And what about data? That is definitely excluded. If they say presentation of information, you could think, okay, it includes data. But this is also as such excluded. So the basic idea is that the basic building blocks of artificial intelligence belong to the excluded subject matter according to the European Patent Convention, as such always. So what do we do there? Of course, mathematical algorithms and computer programs, if they are in a claim and they interact with the other elements of the claim, and in that interaction they contribute to achieving a technical effect, then they are not excluded. They are being taken into consideration. But nevertheless, the basic conclusion remains that elementary but important building blocks of AI are within the gray zone, let's put it like that. And then I do see a tension there. I can get the next one, please. So let's try to find out what are the AI-relevant patent law aspects that emerge after all this kind of analysis. A first question is, where exactly is the invention? So you present to the European Patent Office an AI invention, and the invention has more than one stages. It has the collection of the big data, it has the training of the system, it has the system reaching a level of performance beyond a certain threshold that is then satisfactory to you, and then you have the real operation of the system. And it may be that you don't use an off-the-shelf neural network or a system, but you yourself develop the system. You influence, for instance, the architecture of the neural network, the number of layers and the number of connections and the different functions that are involved in the neural network. You can influence that. Or you can very carefully choose the data so that your data is more representative of what you would like to train the neural network for. Or you may even engineer the data. So you can take the basic data set and you can make more data out of the basic data by engineering the data, by copying them and changing them a little to use them for training. And so you can influence the training regime. How do you train the network? You can influence that. So there are more than one questions when you ask yourself, where exactly is the invention? And there are more than one possibilities. Then another issue arising is clarity and sufficiency of disclosure. It has been very often said, neural network, this works like a black box. You train it, you put data in there, the network somehow learns a concept and then you get output. But what exactly happens in the network, it is difficult to find out. So examiners will look very, very carefully into the sufficiency of disclosure issue. And you will often get an objection from the European examiner saying you haven't disclosed sufficiently your AI system such that a skilled person can replicate it, can implement it. And this is another requirement of the European Patent Convention. But then I have mentioned already the next issue, the person skilled in the art. We call it person skilled in the art, SIDA. So what is now, in view of AI, the person skilled in the art? What are his or her skills? Do we extend the skills? Because this person now knows more about AI. What is in the toolbox of this person? Does AI belong to the toolbox of this person? Which kind of AI? How much AI is in the toolbox of this person skilled in the art? And coupled to this issue, what is prior art now? How much AI does belong to the prior art, which is available for the examiner to compare with the application at hand? So there are some issues that the European examiner is now confronted with, which are rather new. May I have the...
I have a question. If
yes, please.
I'm taking leverage of asking us if we can ask through the presentation. So
of course, of course.
I think it's relevant to these points. What's your views personally on the incorporation of existing softwares? So sometimes some people come to you, say to you, oh, I'm training my algorithm using the Pythons and the MATLABs and all these things. What's your views into this? Is it something of the components here you look at and in terms of patentability or IP and all this? Or?
Yes, whatever is commercially available, which means that it belongs to the toolbox of the of the person skilled in the art
Okay.
is part of the prior art. Now, let's say MATLAB. Okay, you take off-the-shelf MATLAB, but then it is not ready to be used. Then you have to use it, you have to train it first. So you can be creative by training, by using certain data, by training in a certain way, and so on and so on. So to what extent MATLAB belongs to the state of the art, and to what extent the inventor has used it in a creative way to create something not obvious. That is a question that the examiner has to resolve.
So it fits with those things.
Yes. For instance, I have an analogy. It's good that you asked me. So we open a parenthesis. I have an analogy, and the analogy is that in normal computer science, an inventor invents something and says, I use MS-DOS, which is a very, very old operating system. Now, MS-DOS, simply by referring to it, implies the functional features of MS-DOS, and they are very well known. So all of this belongs to the state of the art.
Thank you.
The same goes for Windows or for Unix. So I just happen to be quite old to have used MS-DOS in my youth. This is why I refer to that. Okay, so another issue that has been very, very often mentioned and quite analyzed also in this conference is inventorship. So who invented? The name of the case of Davos has been quite extensively analyzed, so I will not recur to that. But just a question. If the inventor didn't think about the functionality that eventually resulted out of the invention, is it okay that the inventor pretends to be the inventor? That is a question that we will take up during the example. Okay, so the level of inventive step, should we raise it now? Because the skilled person has a lot more tools in his or her toolbox. Maybe we should raise it. What if the data that were used during the training were used in a non-authorized manner? There is a directive from the Commission and the EU. So the Commission of the European Union has issued a directive that deals with this. How do we deal with non-authorized use of data? And there is also a provision in that directive about text data mining that is relevant. What happens if data are used that were copyrighted, but still used for such an objective? But anyway, I wouldn't like to analyze too much. What happens if the operation of this AI is in a certain jurisdiction unlawful or non-ethical? Because it may be that a certain system is used in more than one jurisdictions, and these jurisdictions don't have the same standards as to what is lawful or unlawful, or as to what is ethical or non-ethical. So you could tell me, but that is not an issue of the patent law. That is an issue of a different body of law. Okay? But nevertheless, there is some kind of correlation. What if, and I think Kirk mentioned that, what if the data collection, the training, and the performance of the invention takes place in different jurisdictions? What happened? Where is the infringement then? I wouldn't like to go very, very extensive over these things. I would like simply to mention these things as challenges for the patent law. Many of these things don't have, many of these questions don't have answers yet, but nevertheless they arise, and lawyers have to deal with that sometime. Now, let's see the example a little more in detail and try to find out what kind of issues the European Patent Examiner would have to resolve when dealing with this application. What would be the issues? Now, the first thing is, we have a system that recognizes a person's mother tongue from audio samples of this person speaking English. Is this technical? Technical is the holy grail of the European Patent Convention. If it is not technical, if it is judged to be non-technical, then the examiner practically will say, sorry, objection, it is not technical, go home. Not exactly like that, but nevertheless, yeah, sort of. But, so we have a system that does something that normally is a mental process. If you, as humans, do this recognition, it is a mental process. Huh? So, you listen to me and say, oh, you're not a native speaker of English, and judging by your accent, you're probably Greek. And this can happen a lot. Is this a technical task? What would you say?
I would say no for me, I don't know. I'm not an examiner, so...
yeah, but I'm asking about your feeling, because my feeling is it's a mental process. I cannot imagine that it is a technical task or a technical process. It's a mental process. And now we simulate it with an AI system. So probably the European Patent Examiner would have an objection if, at least up to this point in the claim, saying, sorry, this is a mental act, and if you read the European Patent Convention, then mental acts as such are excluded from patentable subject matter. Okay, but then I, as the inventor, would say, no, wait a minute, this is a simulation of mental act. I don't have a human. I don't claim a human doing that. I claim a system doing that, so I simulate the mental act. Then the examiner would say, oh, but the Board of Appeal hasn't issued any guidance yet as to whether simulation of mental acts is a patentable subject matter. So maybe we have to wait for the Board of Appeal. No, that's not the patent examiner has to decide somehow. And if the case goes to the Board of Appeal will decide, and what they say goes because they're gods. So it is an issue. Okay? Then we have the training, and trained with enough audio samples from different persons, obviously, with different mother tongues, obviously, till success rate is above predetermined threshold. So you have to have the system functioning up to a certain level so that it is operational. Then the examiner will say, so you train, but how do you train? How do you choose your training data? What kind of training regime do you follow? Is it a supervised learning training? Is it a non-supervised training? What exactly do you do there? And that would be a basic lack of disclosure, lack of sufficiency of disclosure objection from the European Patent Examiner. That I almost envisage that, I think it's almost sure, almost. Then you would say, no, but the audio samples consist of a spectral analysis using novel algorithms. So you record the speech and you analyze it. It's an audio sample. It's a recorded audio sample. You analyze it with a novel algorithm. Then the examiner would say, oh, so you use an algorithm. An algorithm is a mathematical method. But okay, you use it for a technical thing because you classify, you categorize according to the analysis. So I don't have big objections there. But what algorithm do you use? Which algorithm? You haven't told me. So that would be a lack of disclosure objection from the examiner. And eventually you use that to offer intelligent chatbots Chatbots are these things that you have on your screen that communicate with you. Maybe they communicate in writing, but there are chatbots that communicate orally, and so I talk to them, and the reaction comes up. So you're probably Greek, judging from your accent. So let's talk in Greek from now on. And then that is an intelligent interface, and man-machine, person-machine interface. Very intelligent. It recognizes that I'm Greek. But is that a technical task? Is that a technical thing to program such a chatbot? Now, if you read in the guidelines of the European Patent Office, there is a part dedicated to interfaces, and there you will see that if the interface works on the perception part, so getting the, let's say, if it works not on the cognitive part, so if the interface doesn't work with the meaning of your words, but it works in the perceptive part, if it processes the oral spectrum of your speech, then it's probably a technical thing. So, no big deal there. The examiner would say, okay, it's a man-machine interface, and it is a technical thing. I don't have a problem. But what if you don't use it to program intelligent chatbots, but you use it in order to, in law enforcement, in order to recognize the origin of a person? A person pretends to be Greek, but the system says, no, he or she is from another origin. Is that a technical implementation? Is that a technical task to identify the origin of a person? That I put a question mark on that. And the European examiner would probably have a question mark there. Okay, so does it still work?
Yeah.
So the idea was to showcase the possible issues that arise from, let's say, this kind of technology, not necessarily to give answers, but I think that I tried to show the issues that eventually will have to bother the European Patent Office. So eventually, I had to show, to demonstrate the issues that eventually will have to bother not only the European Patent Office, the law in general. And the law maybe has to provide some kind of response, some kind of answer. So if I could have the last one. So it may be that this basic EPO attitude, AI is nothing more than mathematical algorithms and computer programs. It may be that they have to rethink this basic attitude and go and think a little further than that. It may be that I said that maybe it's an oversimplification. Why? Because from what we said up to now, I think that we have understood that we have a shift of paradigm here when using AI. We go from a basic conclusion drawing method, so we don't draw conclusions from the generic to the specific, as in traditional programming, but we train models with examples and we reach a generic concept. We identify regularities, so we go from the specific to the generic, and that is exactly the opposite of the traditional computational paradigm. This I would like to stress, because I really believe in that. And it may be that the examination practice that worked well for the previous paradigm, for the traditional computational models of the past, it has to be revised. It may be that we have to think a little harder and maybe come up with more inventive concepts to deal with this kind of technology. Thank you very much.
Yannis is very enlightened
The mic, please.
and very exclusive. So, question, welcome.
No. For the moderator, use the mic, please. We can't hear her here. No, I can't hear the moderator, so she can please use the mic.
So, I'm just saying this is a very explicit and very enlightening speech. So, any questions you would like to address to our speakers? Is there any questions? So we thank you for our honorable speakers. They are very comprehensive and very detailed presentation today. AI, machine learning, and big data analysis does change our IP practice. U.S. legal profession no longer exclusively drive U.S. intellectual property law to push the world to follow U.S. will. Intellectual property is increasingly controlling the legal profession and the practice of the law. Technology and intellectual assets are forcing the legal profession to adopt the AI, machine learning, big data analysis, for example, automation, DIY law, checkbox, privacy, and data security for virtual lawyers. So we change the legal practice and also cause change for our profession. For it's not only in patent, the copyright, the time shifting, and space shifting, patent software, any under the sun that is made by man, or the trademark, smell, color, sounds. Patent drafting can be done by AI, and smart contract can be done by automation. Inventorship, ownership are changing their definition now. The trendy application through the emerging technology, product search, patentability determination, patent acquisition, patent assertion, investment. So the world is changing a lot. So it's a law, nothing more than a process that can be coded, or it's the analytic engine better than an emotional human being. So, but it's software always there and can be always on. So today the closing thought there will be, well, we are aware the lawyer no longer need to have office, but can the cloud-based law firm actively protect its client? Are the lawyers more subject to be hacked and intrusion, and can the virtual lawyer ethically represent the client? Or what does the lawyer can offer now? So can the experience and our intuition be coded by machine learning? So there are a lot of coming challenges. So thank you very much for all our honorable speakers, and thank you for our audience attention. If you would like to ask questions after we close the session, you're most welcome to continue the conversation during the conference. Thank you very much.
Algorithm. This is the right assumption or not, because I'm always struggling. I'm not a mathematician, but I'm struggling with my professors. And when we go through the dissecting their invention disclosure and all these things, somehow you will know better than me. I see the novelty almost most of the time lies within the algorithm. I don't know, is this right assumption, or from your experience, no, you should look at primarily other functionality within the whole system component of artificial intelligence?
So I actually had an issue with this with one of my clients, because the problem is that the more you dig into our AI, the more pure math you see, and that's just an anathema to most patent offices. However, there, at least in the United States, I'm not sure about Europe, I might need to get his thoughts on this, there is some language talking about the idea that, you know, if we really boil down those computers, they are functionally working on bitwise arithmetic and things like that. So if you really dig into them enough, you're going to find math somewhere, right? I mean, eventually you'll get there. So the way we handled it at the time was to sort of robustly describe the idea that, look, yes, the algorithms are absolutely the biggest part of this, and those algorithms are supported by mathematics. Ergo, if you were to dig in hard enough, you were just going to find formulas on formulas on formulas, right? You could represent the entire mesh of the nodes, each individually weighted. You could get into that gamesmanship, and you have what it functionally looks like, you know, a mathematics problem. But what we decided to do was to characterize it as saying that it's no different than, say, the operation of a computer, where obviously those you could reduce down to a series of millions of different bitwise operations. It doesn't make them less sort of eligible for patenting as long as their other aspects are met. But the problem is I'm not really sure how that'd fly in Europe, so I'm going to leave it over to him.
And by the way, I like your part where you said really an important diligence part in figuring AI to look back at the invention, not like before, and dig deeper and see exactly what are the components are like.
Right.
Thank you so much.
I do see two differences with traditional mathematics. I agree with you. It is essentially it is mathematics, but the two differences I see is that we have here a kind of hybrid situation. We have mathematics applied on a structure. I have in mind this neural network structure, which is a structure with a lot of layers. We have an input layer, you have intermediate layers, and you have an output layer. You have a lot of connections from the neurons in each layer to the next one. You have also back propagation, so you have connections that go backwards. So that is already something that you can visualize. It is a model, an information processing model. And then you do have a lot of mathematics, because in every neuron there is a mathematical function that somehow aggregates the signals that go in and calculates something and gives a signal to the next neuron. And then the other thing that I do think is here different, there's a shift of the paradigm, is what I try to indicate, the shift from, well, I wear now my mathematics hat to say the shift from deductive inference to inductive inference. And in plain English, that is the shift from a paradigm where you program something from the general case, a salary calculation system. You program it for the whole company, and then you feed in the personal data for Yannis, and the system calculates the salary of Yannis. That is from the general to the specific. And now here, to my mind, we have exactly the opposite. You show an AI system a lot of pictures of dogs. And the system forms an internal representation, mathematical one, of what is a dog. And if during operation you show to the system a new picture of a dog, the system says this is a dog. And if you show it a picture of a cat, then the system says this is not a dog. So you program the system for the general concept, and the system identifies a answer for the specific. So you go from the general to the specific, not from the you go from the specific to the general, specific dogs, general dog concept, and not from the general to the specific, salaries of the whole company, the salary of Yannis. And there I do see a shift of paradigm.
This is very excellent. Thank you so much, Yannis.
You have the question, right?
Hello, I'm Naganan from Bangalore, India. I have two comments, and if you would, any of the panelists would like to say something on that. The first thing was in this translation issue, question whether it was technical, non-technical. I think, the machine, when it does the translation, it does something which the human brain does. If I know 5 languages, if people speak 5 different languages around me, I immediately translate it to the language which I wanted without any effortlessly, because you know the language. But the same process, when it's done by the machine, it's not so simple. So I think it is a case where there is a technical operation that is to be done. And that technical operation is what you are going to build into your artificial intelligence program. Therefore, I think the details of how it reacts and how it converts is very interesting, and is surely mathematical or technical, I would say, because on my handset, if I use English, and if I want to communicate with somebody in either my mother tongue Kannada or Hindi or Sanskrit, I just push a button and I type in English and the other language comes in. I also have the option of typing in the script of that language. So I'm saying this is a technical process, is what I think, so maybe you can say something about it. And the second question is a little more difficult one, I think. You see, we are all filing these patent applications to the patent office. What kind of protection do they have from hackers, from people who are going to, get into and look at your patent application and all the details before even it is scrutinized, do some mining there and pull out some things? Has it ever happened in any jurisdiction? Because today that's a very hard reality that, when hackers can get into the US security system, the US election system, especially our friends from Russia, I think, and China, of course, anything can happen anywhere. Therefore, it is important for us to also highlight that and see what kind of protection is there. Will they indemnify me? Will the patent office, if I sue them for $10 million for infringement at their end, what happens? I think this is something which you could tell me in your experience. Thanks.
I've also a question of the patent office and I didn't get an answer.
Did they send you a check?
I couldn't agree more with you with regard to the first question. My own appreciation of translation is what happens with humans? English, understanding, Greek, and vice versa. So with humans, we have an intermediate step of understanding. What happens with the machine? English, a lot of calculations that have, which precede, of course, the actual translation, where a lot of English texts are fed into the machine together with their Greek translation, and the machine somehow learns to map expressions in one language to expressions in the other. So, to cut the long story short, human, language 1, understanding, language 2. Machine, language 1, result of a lot of calculations, language 2. So the machine has replaced the mental process with some calculations. So I couldn't agree more with you, this is a technical thing. The machine doesn't understand. So you cannot say it's a mental act. It might be that you say it's a simulation of mental act, and then we wait for the Board of Appeal of the European Patent Office to decide on whether simulations of mental acts could be technical. On the second issue, the patent offices all over the world are wise enough not to take any liability for anything that happens after they grant the patent. So, totally excluded.
Any reaction from the US?
I'm mostly scared about our associates saying things. We have spies who actively try to, we have spies who send pretty young girls to our younger attorneys, so that scares me more than anything of that knowledge.
I have a very small comment. You mentioned something about the machine somehow learns. Does the machine somehow learn, or has it been told exactly how to learn?
Maybe it was a little unfortunate that during the whole presentation I used human-centered terms to indicate machine operations. But otherwise, I mean, this is the way we communicate. We talk about machine learning, and in the beginning of my presentation I said artificial intelligence, that is a contradictory term in itself. No, the machine doesn't learn. The machine somehow makes mappings, identifies the humans program it into the machine. But the machine identifies regularities in data, does some clustering, some classification, and it is basically algorithms, classification, categorization algorithms. And in that sense, that was a terrific question, because it gives me the opportunity to say also something else. In my example that I used with the recognition of the mother tongue, there is a continuation of this example. The inventor of this eventually found out that the machine or the system, beyond categorizing the audio samples as belonging to this origin, has produced another output. The machine has produced two clusters, has categorized the samples in two clusters. And the inventor said, oh, but what are these two clusters? And eventually, the inventor found out that one cluster is those samples of people who had British English teachers. And the other cluster was from those people who had American English teachers of English. So in this scenario, the machine did a clustering which was not envisaged by the inventor. It is a Douglas plus, or let's say the son of Douglas. And so I didn't mention that during my presentation, but I had it as an add-on for the end. And that exists. It's not real, of course. It's invented, but it exemplifies functionality that might eventually be visible, not envisaged, not programmed, but still emerged. And who invented it?
Yeah, is there any other question? I guess we have done with the questions, yeah? Okay, Bhumi, I request you to please ask the photographer so that we can go with the last